Welcome to You and the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar, and I have my own firm, Barry L. Gordon and Associates in Chicago, where I concentrate in family law, medical malpractice, and personal injury. Today we're going to have an interesting show, and I ask you all out there, if you're an airline pilot, or you were a Chicago police officer, or a firefighter, you would have irregular hours. You wouldn't be working a 40-hour week, or like an airline pilot, he may just disappear to another country for 3 or 4 days at a time. These are problems that are presented when working out a settlement agreement in any divorce action. And we have with us today a mediator whose sole job is to mediate as well as do other things, and we have with us the Honorable retired Judge Michael Bender. Thank you for joining us today.
Thank you for having me.
It is a pleasure. Judge Bender is a mediator, and what is a mediator is what we're going to discuss today. If I'm an attorney that specializes or concentrates in divorce law, and I have a woman that I'm representing, and she tells me that her husband has irregular hours, and she does not want him to have the child or children more than 1 day a week, but only when he comes in and gives her maybe 72 hours of advance notice when he gets through with a flight if he's a pilot, or if he's in a different type of job like a city worker and there's a special event. These are problems that occur, and we try to work them out with the opposing counsel. For example, the counsel who represents the husband. But if we cannot work them out, we may suggest that they go to mediation with a mediator like retired Judge Michael Bender. And that's what we're going to talk about today. What does he do? What does a mediator do? And the problems and the ways he handles them. How does he handle vindictiveness? How does he handle the psychological problems that these parties present? So let's get started, okay?
Sounds good.
Okay. Let's talk about, first of all, the new act that happened on January 1st of 2016. Now it's a few months later. And the problems that we have is that under the new act, there has to be 3 categories that have to be addressed. And they are?
So we address the decision making. And it's called decision making instead of what used to be called custody. And the reason we do that, or the thought behind it, is custody is an inflammatory word. People come to you all the time, they'll come to mediation and say, I want full custody. And what they mean is, I want to see my children often. So they remove the word and they make it decision making about 4 major areas. They threw in extracurricular activities, but it's doctors, medical, it's religion, and it's education.
So recapping, we've got education, we've got extracurricular activities, and we have the medical, is that right?
And we also have religion.
And religion. So what we're going to do is, what you're going to do as a mediator, you're going to decide which or what portion of those categories are going to be allocated to each individual, husband or wife.
I help them decide.
You help them.
The idea of mediation as opposed to arbitration is the mediator helps facilitate the conversation and helps the parties reach agreement and the way we'll do it is we'll break everything down to its smallest parts and see where the different agreements are, and then talk about where there seems to be a disagreement.
Yeah, but don't you get a party, a litigant, she's going to say, hell, he never paid any attention to these children when we were together. He's a no good.
Well, it can happen, but things are changing. People are getting divorced, and there's a new situation and a new future. So we work with the parties towards reaching an agreement, a reasonable agreement. The alternative is to litigate it and find out the result in 2 years, which is full of anxiety, which is out of their control, costs a lot of money. This is an opportunity in mediation for them to craft their own agreement and go forward with what they know to be something they can live with. Nobody ever knows their lives like they're going to know their lives. So it's an opportunity for them to decide how the future is.
Okay, let's talk about each one of these significant categories that the law has now told us we need to decide. And also, I'd like to mention, you mentioned that, that the word custody is no longer used.
Right, in very limited times is it ever used.
And visitation is no longer used.
Right, parenting time.
But let's face it, years ago they changed divorce to dissolution of marriage. When's the last time a lawyer has received a telephone call from anybody saying, I want a dissolution of marriage? They don't. It's still used, the word divorce is still used.
That's right. However, instead of people focusing on the word custody, because that's what they've heard on television throughout the years, that I need custody, we break it down to, let's not talk about this magic, let's talk about what's important. Can the two of you, how is the pediatrician? Does everybody like the pediatrician? Yes, okay, so you'll agree to keep the pediatrician, and if there's a change, you'll both decide yes. And now one of the custody issues is gone, and then we move on next. We move on to religion, we move on to education.
So there is, correct me if I'm wrong, a lot of issues that have to be decided by the parties. Yes. And I'd like to just go over some of those issues in addition to those categories. There are issues of, here I go, right here. I just want to bring this out, the fact that winter break, who gets the children? Spring break, who gets the children? Summer break, who gets the children? Or what percentage of the time do you get the children? And then we have the other issues of holidays. We got Easter, we got Labor Day, we got July 4th, we have birthday of the children. All this has to be separated now in a divorce agreement.
That's true.
Or, excuse me, dissolution of marriage agreement. And that's where the rift comes in. That's where the problems come in, is that one party wants Christmas all day, and the other party wants Christmas all day. Now, you're the mediator. How do you handle it? I know each mediator is different, but how do you handle it?
So first I have the parties say what it is that they'd like to see happen. And if we find where the agreements are, sometimes Halloween is not important to one person, but important to the other. So they say, okay, I'll take Halloween, and the other person likes 4th of July, so and the other person doesn't. So those are easy issues. Then when you get down to Thanksgiving, and when you get down to Christmas, and sometimes New Year's, yes, it's often very important to both parties. And then you have to talk about how it's alternated, because we bring, I let them realize, which is often the part of divorce that most people don't realize, is you're going to have less time with your children. Now there's 2 households and the same number of children, and it's going to be less. So alternating is a way to do it. Breaking Christmas into Christmas Eve and Christmas Day. Some families celebrate Christmas Eve, some families celebrate Christmas Day, so they work it out that way, and if it doesn't work that way, they'll alternate it. There's different ideas, but the ideas are finite. There are only so many solutions. So for the parties to determine what they want to do then, as opposed to waiting 2 years for trial and 2 years of misery, raising their family, it's a great court system, but the idea isn't to raise your family there. So the judge will decide in 2 years, or you can decide now, and there's only so many solutions. I believe there's nothing that can't be decided at a mediation table that can't be decided in court.
Now, referring to birthdays, I had somebody in the office recently that said, look, I would like to have the child on his birthday, and I don't mind if my husband, who's going to be my ex-husband, if he participates in that birthday party. I've never heard that before. That's terrific, don't you think?
It can be. It can be, and that's an idea that you would hope would continue through. Mm-hmm. Sometimes it doesn't work that way. Sometimes there's a lot of tension. Sometimes it's not enjoyable for the child because there's so much tension, and then in that case you work out something else where they'll alternate it, or somebody they'll celebrate the birthday on their parenting time. Mm-hmm. There's different alternatives to it.
All right, let's go back to these categories of education and extracurricular activities and religion. Let's take religion, for example. What are the issues in religion that you have to decide?
Well, so again, it's for them to decide. I'll draw upon my experience and put out ideas to generate conversation if things are dying down. But I mean, there's a clear issue of the child was raised one way and now somebody is following something else, and they want to expose their child to that religion. There are issues of some people have walked away from religion altogether and they don't want to expose their child to religion. And the issues are vast when it comes to religion. Where the greatest dispute in the most difficult situation arises is if somebody wants to provide a child with an actual religious education in a formal way. When that happens, it's difficult to have two formal religious trainings for the same child. It's confusing. Taking that away, exposing a child to two different religions is a very different thing, and often that's the solution. The agreement will be, okay, well, on your time you can bring the child to your institution, whether church, synagogue, mosque, whatever it is, and the same thing with yours. And that way the idea would be the child would later decide how the child wants to go as an adult.
Yes, I've seen a great deal of that, especially with the Jewish people and the non-Jewish people, where the child will go to church maybe one weekend and maybe the next weekend will go to synagogue and make their own decision when they grow up. Also, we got the issue of parochial schools.
That's right. And sometimes that ties into a financial issue. Often the underlying issue on private school versus public school is a financial issue. And often a solution that can be reached is, well, if he or she wants to put the child in private school and that person isn't going to look for the other party to pay for it, then they're usually okay with it.
Yeah, I can understand that, and that seems to work. So you don't have a great deal of, we'll say, vindictiveness or problems with that issue as much as one would think. Am I correct in that statement? Is that a fair statement?
The vindictiveness is something that we work through in the mediation. So often in the beginning of the mediation, there may be hostility, and the idea is to get them to talk and they may not have communicated for quite a lot of time. And once one person says what's on their mind and they say, this really bothered me that you did this, and the other says, well, you did this, or there's maybe just a complete misconception of what happened. After they're able to talk about that, then we can get down to the issues and say, okay, well, let's talk about how we're going to go forward.
Okay. One of the problems that I find, and I'm sure you do too, is the location of where the parents live. Under the new act, they can't live more than 25 miles apart. Well, let me put it a different way. They can move out of state, but it can't be more than 25 miles from where the other spouse lives. There's also another matter that I wanted to bring up, and that is that a parenting plan must be filed within 120 days of one spouse filing a divorce, a petition for dissolution of marriage, or another spouse filing a reply to that. What does that mean?
So that means that within 120 days, there's supposed to be a filing of a document that breaks down what it is that either party or both parties would like to see about decision making on the four issues that we talked about: doctors, school, religion, extracurricular activities, as well as the parenting time, which used to be called visitation. Now visitation is just reserved for persons who are not the parents, so grandparents, etc. Because the thought process would be parents don't have visitation, they parent.
Well, let me interject just for a moment. Grandparents' statute a couple of years ago was held unconstitutional. That grandparents did not have standing in court to fight for visitation. Do they now have that?
Now the act is very specific as to when and under what circumstances, and it's very specific. My guess is that it was done to be in accord with the case law.
And while we're talking about grandparents, I see a lot of clauses, and I've drawn them myself, called right of first refusal. That means if it's your time to have parenting time, but for some reason you cannot utilize your parenting time, or your boss, let's say, calls you to work that day, can you park the children with grandma? And these clauses say that you first have to give the right to the other spouse or ex-spouse to take care of those children if that spouse is available.
And I see that there's a great deal of conflict there, because people say, well, why can't my child spend time with my mother or my father? We're all a big happy family. And often the other parent will say, well, look, I come first, I'm before a grandparent, and then you wind up with some conflict between mother-in-law and husband or wife, and then it happens, you see it. And you need to balance it out. And one of the ways to balance it out is defining what is the right of first refusal. How many hours away from the child does the parent who's doing the parenting have to be before it kicks in? Is it overnight? Is it 4 hours? Often you want to guard against, well, it's just a normal work period, then everything changes.
So it's your job to guide them into an agreement, giving them your take on what is usually done and how it can usually be developed. Is that a fair statement?
So the thought process on mediation, the actual creation of mediation, isn't for the mediator to do anything but make suggestion. They need to the parties need to come to a conclusion. But it makes no sense for me to sit there with options that they may not have thought of. The key to mediation is to find out what it is that each party really cherishes, what is it that's really important to them, and then helping them find a solution that'll make it a win-win, so that they're both happy and they both can stay with the agreement for a long period of time. And often I'll draw upon my experience, things that I've seen, and put it out there as an option, or guide one of the parties to say that option, kind of maybe a Socratic process of sorts.
Now, let's go to the category of education. What kind of problems do we have there that usually come up in front of you?
So education is often private school versus public school. The location, if it's public school, then the question becomes, well, how does the school itself define a resident? Because the school won't let a child in if the child's not a resident. So different schools have different standards. It could be half the time, it could be a lot of time. So what happens is the idea of what school it is starts to tie into the concept of the amount of parenting time. And you try to limit the parenting time from being determined by the school district, but there's consideration to look at.
Okay, and also when it comes to the category of education, we need to talk about who goes to parent-teacher conferences, right?
Right.
And also who gets copies of the grades and who gets copies of whatever report the schools issue.
That's true.
And if the child is punished in school, told to stand in the corner for 60 seconds, or back in my day, it's a little harsher, certainly that has to be addressed in your mediation to some extent.
It is addressed, and the conflict that I see is he or she, the statement, he or she didn't give me notice of this school event or this parent-teacher day or this conference. So it's important that the parties have it where they contact the school and the school tells them directly what is happening, and that's in compliance with Illinois law. Illinois law presumes that both parties can access the records.
Okay. Now we got that category of extracurricular activities. I have to assume this includes Little League, it includes well, I'm going to get right to the heart of it. If the child's over 13 years old, there's going to be a problem, because usually children over age 13, teens in their teens, just getting into their teens, don't want to be with one parent when they've got extracurricular activities going on.
No, and they want to participate in the activities, and they have the right to do that. If they're on a team, there's, how could they say, I'm not coming to practice on Wednesday nights and Saturdays and every other Friday, they have to be there for the team.
But you're going to come into a situation, I'm sure you have, where let's say the father can only see the children on a weekday, on a weekend day, a Saturday or a Sunday, and that may be the day of the extracurricular activities.
And they can go take the child to the activities and celebrate afterwards and be part of the child's life. It's parenting time. It's not playtime. It's not babysitting.
Well, okay, that's really a fair answer to that. Is there anything else that I'm missing in extracurricular activities?
So, typically with extracurricular activities, there's a couple things that people are concerned about. One thing they're concerned about is that there's going to be an excessive price. One parent is just going to sign, especially with little children, one parent is just going to sign the child up for 7 activities in 7 days, and it's just going to be too costly, and that could be solved by putting a cap on the responsibility of the other parent. Mm-hmm. The other is when the parent signs the child up for activities that also include the time of the other parent, but they've never discussed it with the other parent. So whether it's done maliciously or whether it's just a matter of not really considering the other person's feelings or their time, often the agreements will state either parent can sign the child up for extracurricular activities on their time, and if they want to have the child participate in an activity that is on the other parent's time, it has to be with the consent of the other parent.
Okay. Now, it's my understanding, and maybe you could develop this more for the audience, a lawyer can now be present during mediation?
I actually prefer the lawyers to be present. At least in Cook County, our culture for a long time was that the parties would go to a mediation where the attorneys were not allowed to be. Mm-hmm. So the parties would be sent out to mediation, and they would try to resolve only non-financial issues, whether it be parenting time or decision making, and then everybody would wait to see what happened. So in private mediation, the opportunity for attorneys to be there it exists because that rule doesn't exist. I prefer for the attorneys to be there, and the reason is this. The mediator is a neutral. The mediator is not to give legal advice, not to say this is wrong and this is right or this is an impossibility, but to actually be there as a neutral. And once a mediator starts to, you don't want the mediator shouldn't give the impression that they're biased one way or another, or they have no ability to mediate.
Right.
So, and to help these people. So if the attorneys are there and something is being discussed, the attorney can lean over to the client and say, we're not going to do it that way. That's not the right way to do it. And then the mediator isn't in a position to have to be concerned that somebody's trying to make an agreement that they shouldn't make.
Now, correct me if I'm wrong, but wouldn't it be offensive if a lawyer was there and is trying to impress his or her client by constantly interrupting you and making a point that their client can say, oh gee, I'm glad my lawyer's here because he's really fighting for me. Doesn't that interfere with the whole process?
That's for the mediator to stop. That's true. Most attorneys are respectful of the process, and they say, can I say something? Can I, they ask. The mediator can't let the attorney take over the room. It's not going to work. The attorney has to keep the sides of the table balanced, and this leads into domestic violence mediation too, which I also do. It's important that the people are entering into an agreement that they are not under duress for, that they are consenting to, and it's actually their will, because again, the concept is you want them to reach an agreement that they're satisfied with. So if they were forced into it, it's not going to be an agreement that lasts very long. So the mediator has to make sure that if there is an attorney who is overly aggressive, that the mediator tactfully tries to tone it down.
Okay. Now, it's my understanding also that you do not only mediation, but you do what else?
Well, I also represent children as a child's representative and a guardian ad litem, and I represent some individuals selectively in their dissolution or parentage matters.
And your firm's name is?
The Law Office of Michael Ian Bender.
Michael Ian Bender. Okay. Now, In going on here, what should a person look for in a mediator?
I would say experience is number one, because you're gonna want somebody who is able to draw upon their past to help out with solutions that the parties may not have thought of. Somebody who they're comfortable with. I think that's important too. There's different people and there's different personalities, and I think a comfort level is important also.
Okay, now there are some drawbacks of mediation that I've discussed with other people. Mediation is not for everyone. A party may be unready or unwilling to sit down and mediate, and the party may not be able to control their anger. Is those fair statements?
The only time that I think mediation isn't appropriate yet is during financial mediation, when discovery has not occurred. So if everybody doesn't know what the income is, what the expenses are, what the assets are, what the debts are, if they don't know, they can't really mediate it, because they don't know what they're trying to either split up.
Okay, and what traits that are good in a mediator would be their credentials, their licensed attorneys, and the rapport, and whether or not a person's comfortable in sitting down with them and they don't want to feel rushed. Now, having said all that, I think we accomplished a lot today, and I think that the people out there in the audience have an understanding of what goes on with mediation, and it's really a difficult job for you, Judge, to sit down with people every day and try to work out their problems. And I know you have to report to the court and so forth, as well as to the attorneys that may have recommended them to you. And I think it's really wonderful that we have mediation. And under this new act, it's a problem. Everything's a problem, because it's all something we have to work out. The judges have to learn it. We have to learn it. And we're coming across a lot of stumbling blocks, as well as the fact that we have this new take away the word custody, take away the word visitation. That's a real problem for people. They just don't understand it. But I want to say this, it's a pleasure having you today.
It was a pleasure to be here. Thank you for having me.
You're welcome, and I want to thank the viewing audience. I want to thank you all for watching You and the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon. Thank you.